Wyoming has a straightforward and landlord-friendly framework for breaking lease laws, with minimal statutory regulation and broad enforcement of lease terms as written. If you're a landlord or tenant in Wyoming, the lease agreement itself is your primary governing document. The state has not enacted the detailed early termination protections found in more heavily regulated states. Wyoming's landlord-tenant statutes are found in Wyoming Statutes Title I, Chapter 21, and the state has not adopted a comprehensive version of the Uniform Residential Landlord and Tenant Act. This means the landlord-tenant relationship is governed primarily by the lease terms, common law principles, and limited statutory provisions. When a tenant breaks a lease in Wyoming, the tenant is generally liable for the remaining rent under the lease term, unless the lease includes an early termination clause or the tenant has a legally recognized reason for breaking the lease. Wyoming courts enforce lease agreements as written contracts, and a tenant who abandons a lease without legal justification faces potential liability for unpaid rent through the end of the lease term, plus any damages to the property. Wyoming does recognize the landlord's duty to mitigate damages, though the duty is based on common law principles rather than a specific statute. When a tenant breaks a lease and vacates, the landlord must make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit vacant and hold the departing tenant liable for every month of remaining rent without attempting to find a replacement. However, what constitutes reasonable efforts is evaluated on a case-by-case basis, and Wyoming courts generally give landlords reasonable discretion in how they market and re-rent the unit. As a practical matter, the landlord should document their re-rental efforts, advertising the unit, showing it to prospective tenants, and processing applications in a timely manner. If the landlord successfully re-rents the unit, the departing tenant's liability is limited to the period between their departure and the new tenant's move-in, plus any reasonable costs the landlord incurred in the re-rental process, such as advertising expenses and any rent differential if the new tenant pays less. There are several legally recognized reasons a tenant can break a lease in Wyoming without full financial liability. Military deployment or permanent change of station is protected under the Federal Service Members Civil Relief Act. Active duty service members who receive qualifying military orders can terminate a residential lease by providing written notice along with a copy of the orders. The lease terminates 30 days after the next rent payment is due following delivery of the notice. This federal protection applies in Wyoming regardless of what the lease says, and landlords cannot penalize military tenants for exercising this right. Wyoming has a meaningful military presence, particularly at F.E. Warren Air Force Base in Cheyenne, so landlords in the Cheyenne area encounter SCRA terminations regularly. Uninhabitable conditions can justify breaking a lease in Wyoming. If the landlord fails to maintain the property in a habitable condition, including functioning plumbing, heating, electrical systems, and structural integrity, and fails to make repairs after reasonable notice from the tenant may have grounds to terminate the lease. Wyoming's habitability standards are less detailed than many states, but basic habitability obligations exist under common law and the limited statutory framework. The tenant should document the conditions, provide written notice to the landlord, allow reasonable time for repairs, and keep records of all communications before breaking the lease on habitability grounds. Landlord harassment or illegal entry can justify lease termination. If the landlord repeatedly enters the property without proper notice or consent, harasses the tenant, or interferes with the tenant's quiet enjoyment of the property, the tenant may have grounds to terminate. Wyoming doesn't have a specific statute detailing landlord entry notice requirements the way many states do, but common law principles protect the tenant's right to quiet enjoyment. Wyoming does not have a specific statute protecting domestic violence victims' right to break a lease early. This is notable because a growing majority of states have enacted such protections. In Wyoming, a domestic violence victim who needs to break a lease for safety reasons would need to rely on general contract law principles or negotiate directly with the landlord. The absence of a specific statute means there's no guaranteed right to early termination based on domestic violence status. Early termination clauses in Wyoming leases are generally enforceable. If the lease includes a provision allowing the tenant to terminate early by paying a specified fee, typically 1 or 2 months' rent plus forfeiture of the security deposit, that clause is enforceable as written, provided it was agreed to by both parties. Wyoming courts respect freedom of contract, and early termination clauses are treated as valid contractual provisions. For landlords, including a well-drafted early termination clause in your lease is a best practice. It provides a clear, predictable framework for early departures. The tenant knows the cost, you know the compensation, and both parties avoid the uncertainty of litigation. An early termination clause that requires 60 days written notice plus a fee of 2 months' rent is common in Wyoming and provides the landlord with enough time and financial cushion to find a replacement tenant. Wyoming does not have a statutory limit on early termination fees. The fee must be reasonable. A fee that's clearly disproportionate to the landlord's actual damages could be challenged as a penalty clause. But Wyoming courts generally give parties broad latitude to set terms in commercial agreements, including residential leases. From a practical standpoint, Wyoming's small and geographically dispersed rental market affects how breaking lease situations play out. In Cheyenne, the state's largest city, re-renting a unit is generally feasible within a reasonable time frame, and landlords who make good faith mitigation efforts can usually minimize their losses from a broken lease. In smaller communities, particularly in rural areas, the re-rental timeline may be significantly longer, and a broken lease can result in extended vacancy. This makes the early termination clause especially important for landlords in smaller Wyoming markets, where the practical cost of a broken lease is higher. Landlords near F.E. Warren Air Force Base should anticipate SCRA terminations as a normal part of doing business. Military tenants rotate regularly, and SCRA-protected terminations are not lease violations, they're federally protected rights. Building this expectation into your business model and maintaining a ready list of prospective tenants helps minimize vacancy when military tenants exercise their rights. One best practice for Wyoming landlords: include a clear early termination clause in every lease. Specify the required notice period, the termination fee, and the process for returning the security deposit. A well-drafted clause protects both parties and eliminates the ambiguity that leads to disputes. Without a clause, you're relying on common law mitigation principles and potential litigation to recover your losses, which is more expensive and less predictable than a contractual solution. Another best practice: when a tenant breaks a lease, document your mitigation efforts immediately. Start advertising the unit within days of learning the tenant is leaving. Keep records of every listing, showing, and application. If you end up pursuing the departing tenant for unpaid rent, your documentation of reasonable mitigation efforts is essential to your case. A Wyoming court will expect to see that you made a good faith effort to minimize your losses. For the complete guide to Wyoming breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.